Good afternoon. Hello, Mr. Steven. Hello, Ms. Bukola. Good afternoon.
Good afternoon.
Good afternoon. How's your day going?
Fine, thank you.
Okay, I think I'm on. Okay.
All right.
Thank you very much. Is my audio functioning? Can you hear me? Hello?
Okay, webinar now. Yes, Mr. Steven, I can hear you clearly.
Okay, thank you.
All right. All right, so we'll begin the webinar now. Thank you very much, everyone, for joining today's webinar. It is an honor to be asked to moderate today's webinar, and I'm pleased to introduce to you our speakers that we have here today. We have Mr. Ikemefuna Stephen Onweye, who is the founder and managing Oki Ogusha and Ed Satoshi at BBO Solicitors. We have Ms. Zainab Babalola, Ed Legal and Compliance, NAST OTC Securities Exchange. We will not be joining us today due to some matters of urgencies that came up as of late. And we also have our last speaker, who would be Mr. Samuel Ungu, an associate at Alliance Law Firm. Before I go on to hand over to our speakers to the presentation, I'll just talk a little bit about the company I work for. ESQ Trainings. At ESQ Trainings, we focus primarily on delivering trainings to companies, law firms, and business owners. Our mission is to expand the frontiers of continuous professional learning with trainings and courses across various areas of practice. We have tagged this webinar series the Launch Hour webinar series, and they are slated to hold twice every week, Tuesdays and Thursdays, respectively. And after each of the webinars, we provide the video and the materials on our YouTube page, My ESQ Legal. And today we are considering, Nigerian data protection regulation implication for the Nigerian capital market. And the webinar is intended to provide capital market operators, lawyers, risk and compliance professionals, practitioners, and investors with an outlook on regulatory issues in the Nigerian capital markets under the Nigerian data protection regulation. And we are hopeful that at the end of this webinar, every of our attendees, we understand the fundamentals of the Ndpr, that is, who is impacted by the Nigerian data protection regulation, what are the consequences of non-compliance with the Ndpr. And we also examine the legal and regulatory framework of capital markets. We'll look at the challenges and the opportunities presented by the Ndpr for the Nigerian capital market and the capital market operators. And we'll look at technology solutions for compliance, as well as the implications, compliance plan, and checklist for capital market operators. Without further ado, I'm going to call on our first speaker, who will be taking us through the introductory aspects of the Nigerian data protection regulation. Welcome with me, Mr. Ikemefuna Stephen. You have the floor, sir.
All right. Good afternoon, everybody. Thank you very much to Esquire Webinar Series for making this webinar possible. I was really excited and let me say, use the word intrigued when I saw the topic, particularly given the very important nature of the issues to be discussed therein. So what I would like to do with this is I would like to go on straight to my presentation. I have some slides that I've put together for purposes of this discussion. I don't know. So would the host help me share the slides, or should I just go on and I don't know? Should I use the share screen to share it?
Yes, you can. You can go ahead to share the slide. Yes.
Okay, let me see if I can quickly find that and put it up. Just give me a second. I'm having a bit of a challenge here. Please, I don't mind if you just, I'll just put it up for me, please. It's okay. Let me
Okay,
just
that's fine. No problem. I'll do that.
Thank you. All right, so yes, this is us here. So the first slide talks about data list number 2. That is the data privacy and protection legislation. Yeah, okay. Okay, thank you. Thank you very much. Okay, so I will move to slide number 2, please. Mr. Aki, are you there?
Yes, sorry, I had moved to the second slide. I don't know why it's not reflecting on the screen.
All right, thank you. Thank you very much. This is fine. So I think it's important to really pretty much lay the foundation for today's presentation, particularly on the issue of the Ndpr. We want to talk about data protection, issues of privacy. There are several issues that come to mind. But importantly, I want us to understand that at the very foundation, at the very basis of this discussion, is the Constitution of the Federal Republic of Nigeria. The Constitution is the ground norm, is the fundamental law, is a law that's upon which every other law or legislation is anchored or is built upon. And if you look at the Constitution, particularly the provisions of fundamental human rights, Section 37 talks about right to privacy. If we look at the exact wordings of that particular provision, it talks about every citizen is guaranteed the right to the protection of their home, their correspondence, their telegraphic communication and conversations, and that it is guaranteed and protected. Upon this very particular section, pretty much every other thing we're going to talk about is anchored or is built. And afterwards, the government has taken time to enact several legislation. Over the years, we've seen that things evolve, things move from paper-based communication, paper-based transaction to online or digital platform or electronic platform. There has been a need to create some form of legal regime, legal framework to ensure that the rights of people are protected, to create a balance between what you may call national security and personal right to privacy and right to protection of every information you put out there to the public. And if you look at the legislation outlined, I pretty much know this in a particular order, but look at the Freedom of Information Act. The Act says you can have access to government information. The Act gives you a lot of power to go to a government office to demand for certain records. However, there are certain clawbacks in that particular legislation. It talks about certain protections you must ensure when you're accessing information and even you are putting out information that you've accessed. And in 2007 particularly, the National Identity Management Commission was created. I did remember vividly that the then President Olusegun Obasanjo, did make a strong case for us to have a database whereby every Nigerian will be captured. And it pretty much mirrors what you call the social security system in the United States or even in some other European countries, whereby you have a unique number that is attached to your person. So once they put up that number, we can see everything about you. We can see your name, your date of birth, your particulars, right? That was the very idea. And that was because at that time there are issues as to whether if certain people who were going out there claiming to be Nigerians were indeed Nigerians. We didn't have a national database. We didn't have a place where we could pretty much verify people's record, who they truly are, or if they are who they claim to be. So that really necessitated that law. And the president made a strong case for us to create that system. And over the years, a lot has been done to improve on what has been created, particularly in terms of identity management and what have you. So when you talk about NIN, National Identity Number, National Identity Card, is an offshoot of this particular legislation. I know at some point the telecommunications people made it a mandatory requirement for you to own a phone or to even own a line in this country. But most of us fail to realize that that was the brainchild of the former president as far back as 2007. And over the years, we try to incorporate it all to the point that for you to even get a driver's license, you need your name. For you to get your voter's card, you need your name. For you to get your international passport, you need your name. For you to even do certain things now in the country, if you don't have a name, you probably must not do anything, without that. And same goes for what you call the BVN, the bank verification number, that is pretty much attached to financial records and purposes. But then you now look at the same time, we also created what they call the National Information Technology Development Agency, NITDA, in 2007. And that is pretty much what we're going to discuss on. It's pretty much the foundation of the regulation we're going to anchor much of the discussion on. NITDA is the agency responsible for managing every electronic communication. So if you look at the particular provisions of NITDA, it says electronic governance. So you think of anything electronic as far as your data is concerned, as far as your personal details are concerned, think of NITDA as the agency that is given the responsibility to manage it. And it was on the premise of that law that NITDA enacted the National Data Protection Regulation of 2019, which is pretty much going to come up in subsequent presentations or subsequent slides. Then we also have what they call the Cybercrime Act. That's especially aimed at this more or less checkmating acts of terrorism, acts of frauds, acts of arcane and what have you not. It's a very elaborate legislation. In a recent litigation, I was pretty much engaged in dealing with certain sections of that particular law. But that is that for that. So these are pretty much the enabling constitutional and statutory framework upon which the regulation is anchored. If you look at the guidelines, it talks about that the NDPR is almost the European equivalent of what you call the GDPR. So the GDPR is pretty much the first world globally acclaimed regulation on data protection. It was a regulation enacted by the European Parliament back in 2000, I think as far back as 2016. And it was aimed at ensuring that the information of people were protected. So as Europe got integrated economically, there were a lot of people exchanging information from countries to countries, from cities to cities, from London to Milan, from Paris to Berlin. It was pretty much a whole digital world, the whole digital platform. And there were concerns as to who had access to what, who could use what, who could do what. To what extent can the man in Milan, for instance, or the man in Berlin, or the man in Paris have access to the details of the man in, for instance, let's say London, and the man in, let's say, Dublin. These are the issues that throw up, and the need for a law or regulation to ensure that the rights of people were protected. And that was where the GDPR came about. Ours in terms of our regulation here in Nigeria mirrors a lot of the provisions of that particular legislation. And having said that, you also want to keep in mind that it is not exclusively the NDPR that protects data. There are issues like the National Cybersecurity Policy and Strategy. The telecommunication world pretty much has a lot of regulation on data protection and issues of privacy also. So when you see the NCC regulations of creation of 2011, that pretty much informs the whole capturing of individuals, who has what line, who's using what line. That was a regulation upon which registration of telephones protection framework, what information is relevant, what is not relevant, what you can get, what you cannot get, what you must provide as a matter of mandatory requirements of the law. Then we talk about the Consumer's Code of Practice. There are lots of legislation and regulations out there, but these are pretty much the salient ones. Recently, I know there's a data protection bill that is pending that was sent to the National Assembly. It pretty much mirrors what you have in the regulation, but in a more elaborate scale. I didn't include that yet because it's not yet a law, to the best of my knowledge. It's still undergoing deliberation before the National Assembly. And once it becomes a bill or an act of the National Assembly assented to by the president, we'll be able to look at it critically, look at its provision, look at how it impacts on what we are doing at the moment, look at its implication for hitherto existing laws and legislations, right? And then we'll be able to have a conversation from there. So, having said this, slide 3, please. Slide 3. I would like to move on to the basics. The basics of the National Data Protection Regulation, I've talked about that it is pretty much a statutory bylaw, enacted pursuant to the Nigerian Act of 2007. I said that, and I talked about what we should think. So when you think of the Ndpr, think of electronic governance. It's pretty much developing regulations to govern electronic governance, the use of electronic data, for any form of electronic communication or transaction in any sector, from government to commerce to education to the public sector to the private sector to labor, any sector you can think of, that has to do with some form of electronic or digitalization of information, you will pretty much think of this regulation. It doesn't matter whether you say private sector, it doesn't matter whether you say public sector. Everybody is affected because at some point or the other, even my small law firm has to do with data processing, data management, data information of myself, of every other employee of the firm, even our clients. So that's how important it is, from an individual perspective. So long as you have a name, you have a date of birth, you have a telephone number, you have every other detail, that is data. And to that extent, it's important that it's managed effectively. And I'll quickly talk about the objective. Essentially, like I said, it's all about the right to privacy. It's all about protecting the individual in this digital world we are creating, or we've already created, or that we're living in, right? So primarily, the first objective is safeguard the right of the natural person to his privacy, to his data privacy. That is very important. It's very paramount. It's the underlying philosophy of Section 37 of the Constitution. It's also the underlying philosophy of the NISDA Act and every other data protection regulation or law you might think of. The second point is to foster conduct of transaction involving personal data, ensure that it's done in a safe way, in a way that it will not expose the person or the people to harm or to having very confidential information out there in public. That's pretty much what the legislation seeks to achieve. It says to prevent manipulation. So in a world where people could manipulate things, people could change things, there's issue of identity theft. Someone could steal someone's identity. Back in the days before we have digitalized international passports, I've heard of cases of people traveling with people's documents, people committing acts to people's identity cards, and people getting arrested, for things they didn't know nothing about simply because someone somewhere has stolen your identity and has used your identity for something else. So this law seeks to prevent the manipulation of data, right? Then, importantly, ensure that Nigerian businesses remain competitive. So in a world whereby there's international trade, there's international commerce, right? You need to do business with a man in London. You need to do business with a man in Berlin. You need to do business with a man in Paris. You need to do business with a man in New York, in a man in Singapore, a man in anywhere, any part of the world. You need to be able to have a system that ensures that any information that is shared in terms of by way of negotiation, by way of discussion, by way of actual contracting, it's authentic. That is not something that can be stolen, something that can be made public without proper consent given. You need to ensure that that is there. So if someone says to you that I'm going to give you certain business secrets, certain personal information about my business, about my person, how am I sure that in your country that it's not going to become something that will be available on the streets of your country? What would you say? I think a Nigerian businessman would comfortably say, oh, you have nothing to worry about. In my country, we have the constitution, but importantly, we have what they call the Nigerian Data Protection Regulation. It effectively takes care of your concerns in terms of what you're giving to us, in terms of what we are giving to you, in terms of everything we're going to do during the negotiation stage, right? So I think this effectively creates an understanding of what this whole piece of regulation is all about. I would talk on the issue of what are the salient provisions in terms of key definitions that we need to keep at the back of our mind. Next slide, please. Yeah, so it says definition of key terms, key concepts, right? So if we look at Article 1.3 of the regulation, there's an elaborate definition of several terms. But I think I identify these terms because it's going to mirror into what we'll talk in the next section as aspects of capital market. It's also very important that we keep this in mind. If you don't remember anything, you can remember these key terms. It helps you understand whether if you're about to do a business, you're about to put out any information to anybody, any organization, whether if you are covered effectively, right? So the first definition that comes here, it says a computer, your phone, your calculator, your wristwatches. These days we have the Apple wristwatch, digitalized wristwatch. It is a computer. It says anything that's capable of processing information, any information technology system, any device, whether it is networked or not, it is a computer. So don't think of a computer from just your laptop, your desktop computer, to your sophisticated iPads, your digital phones. They are all computers, but they are computers up to the level of even a pen, an electronic pen they use in signing. That's a computer because it's an information system. It's a device that you use to process data, you use to process a symbol, which is your signature, right? So if you understand this, that anything that is digitalized, anything that is tied to technology, that it's a computer, then that gives you a proper understanding of what we're going to talk about. Now, data talks about characters, symbols, whether binaries, that is performed or that is used in operation by a computer, which may be stored, which may be processed, which may be transmitted, which may be transferred in any format whatsoever, in any device. That is pretty much a data. So when you put just maybe a dash of a line on any electronic platform, that is a data. If you put a footstop, that is a data. If you write out symbols, if you write out characters, if you write out a name, you're pretty much dealing with data, right? And at that point, it's undergoing some form of processing. But this is the most important one. And I think if we're going to have this conversation, everybody must understand this. It's what we call the personal data. Now, personal data is you, your identity, whether as a natural person or as a corporate entity. It's what makes you you. For a natural person, your name, like I said earlier on, your date of birth, your height, your weight, your hair color, the color of your eyes, your dentition, everything, your facial marks, your blood group, anything you could think of about your person, your phone number, that is your personal data, right? For a corporate entity, the name of the company, the registration number of the company, who are the directors, when was the company incorporated, what kind of business, the articles, the memorandum of association, the address of the business, the assets. Those are things that you can easily verify because they are more or less the personal data of that corporate entity, right? And I did make sure that I did highlight them. So it says anything in the form of a name, address, a photo, email, bank details, your social media, your Facebook, right? Is the personal. Your Facebook page is your personal data, right? Your Instagram page, your Twitter page, your TikTok page. These are all personal data. These days, a lot of these social media companies are now taking steps to verify. So at some level, they say you can verify. So they give you some form of ribbon to say it's an authentic social media handle of this person. However, even though you don't even verify, before you create a social media platform or account now, you are asked for some form of government issued ID. It happens. So you're not going to have an Instagram handle without you bringing a government issued ID card or maybe an international passport for that purpose. Same applies to even creating a Twitter handle, as the case might be. Is that how important it is or it has become in this day and in this age, right? So with the data subject, anybody who can be identified the data subject. So a natural person, even a day-old baby is a data subject, as well as a man that is 100 years old or over 100 years old is also a data subject. So as far as you can be identified, a legal or a natural or a corporate entity that makes a data subject, right? Then processing involves any form of activity you perform on a given data or a given set of data, you're processing it. Whether by way of collection, by way of recording, by way of organization, by way of structuring, by way of storing, by way of adapting, by way of alteration, by way of retrieving, even disclosure. either by transmission, dissemination, making it available one way or the other, you are processing that data. And effectively, you are captured by the law, or you come within the purview of the law. So I'll take the next slide, please. Now, okay, it talks about who is the data controller. It says any person who alone or with others, have the authority, either by way of statutes or by way of contract, to process data or to handle data of anybody, the data controller, right? So now, what is a data breach? What is a personal data breach? It says any accidental or lawful destruction, loss, alteration, unauthorized disclosure, or access to personal data that has been transmitted, stored, or otherwise processed, you breach data for the purpose of this regulation, right? Then who is the recipient? Any person, whether legal, a public authority who receives data. So when you go to the bank and they're asking you for what's your account number, what's your account name, please put your BVN number. The person saying that to you is a data recipient. And that person can also be a data controller or a data processor. So the moment your teller tells you what's your name, what's your account number, what's your BVN number, what's your this, what's your that, the person is receiving data, right? And the moment the person begins to impute that information into a system, the person is processing that data, your personal data you've made available. Now, the man at the back end of the banking hall that has control over the server, over the system, is a data controller, because the person makes available your information through an automated means. Once the system is requesting for, let's say, Mr. Ekeme from Stephen Woye, the person will make available my account details. So you see my BVN, you see my picture, you see my signature, you see the few couple of nairas or dollars I may have in that account. You see the history of the transaction I've done for as long as the system may permit, usually 6 to 7 years. So now, having given this key definition, having explained this, I'll quickly move over to the salient provisions, right? So it says the governing principle of data protection, first and foremost, the duty of care. That is the underlying philosophy. Think about this, that once you're giving out your information, you're concerned about, you wouldn't give out your house address to anybody on the road. Nobody does that. You wouldn't give out your phone number to anybody, but you might give out your phone because in the worst case, you cut the call, right? That's what you would do. But you wouldn't give out, for instance, your BVN, you wouldn't give out, for instance, the original copies of your international passport, your national identity card, your voter's card to anybody on the road. You wouldn't do that. Because when somebody says, let me get this, it raises a red flag. It gets you thinking, what does he want to do with it? Does he want to forge my signature? Does he want to forge my identity? So that is the underlying philosophy. It's a duty of care, it's a duty to ensure accountability. So you just don't go about accessing people's information or processing people's information without ensuring that you protect their person, that you are accountable for that information you're accessing. So bearing this in mind, it is the underlying philosophy for collecting data and processing data. So once you collect, it must be specific, it must be legitimate, it must be a lawful purpose, to which tacitly or explicitly or implicitly, the person must give consent by making available that information to you, right? So the next relevant provision is lawful processing. So once you collect, you must process lawfully within the definite scope of which it was made available. So while consent is important for obtaining, it's also important for collecting, right? I can see that I have 2 minutes for my presentation. So let me quickly walk to the next slides. Next one, please. So I'll just quickly move to the next section. So these are what they are in terms of data security, in terms of mechanism for implementation, and then the next one talks about the penalty for failure to comply with the regulation. That's the next slide. And I'll quickly move on to the capital market section. Yeah, so this is the penalty provision. It says 10 million naira if you default, or 2% of your annual income if you have 10,000 subjects. And that one, if you have below 10,000 data subjects, you pay this. If you're an organization or a person charged the responsibility of processing data. So now we pretty much understand this, right? I'll quickly move on to the capital market section. Next slide. So think data, like I said, any activity on the digital platform, that is data. So let's move to the next one, please. So the capital of the Nigerian financial system, we have the money markets, the foreign exchange market, the capital markets, and the financial derivative markets. These are pretty much what makes up our financial system. Now, the capital market, like we all know, is pretty much regulated by the Securities and Exchange Commission, which is an agency created by the Investments and Securities Act of 2007, right? So for the capital market, we have a primary market, we have a secondary market. Primary market essentially involves, allocating funds through ways of public offers, private placements, and secondary market involves everything you do on the stock exchange. When you go to a stockbroker, want to buy shares, you go to a stockbroker, want to sell shares, right? And think about it. For every transaction you do, you're either giving out your information, from your personal details to your name or your corporate entity, to the amount of money you have for that transaction, to the company you want to buy their shares, and the details of that company. So long as you are doing this process, there's a form of data collection, data processing, and data storage by you, the person you're interacting with, and even the person that's even also interacting with you, in terms of transferring shares to you. So once you think about this whole process, you know that data processing is at the very center stage of this discussion, right? Next slide, please. Next slide. So we'll talk about the regulators. The Corporate Affairs Commission, Securities and Exchange Commissions, NIPC, Federal Competition and Consumer Protection, NOTAB, FRS, the Federal High Court, the National Council of Privatization. These are general regulators. And think about this. To the extent that CAC regulates affairs of every company, private company limited by shares, even the unguaranteed ones, even the business name, even the trusteeship establishments, they collect data in one field from the other, from the name of the director to the promoters, to every details about that particular entity. And same goes for the Securities and Exchange Commission. You can't trade on any security without getting some form of tacit or express approval from the SEC. The SEC is at the very center stage of security dealings and transactions in Nigeria. And to that extent, they deal with tons of data of individuals, of corporate entities. So you want to find out anything, SEC is a public entity, you go to SEC and you obtain maybe some form of permission to do that. And let me say this, right, because every other thing is self-explanatory in terms of specific sector regulator. Now, the market participation, the fund providers are pretty much you and I that go to invest our money in the market. The institutional investors ranges from the unit trusts, the hedge fund, public equity firms, insurance company, pension fund administrators and managers, social insurance trust schemes, sovereign owned entities like the sovereign wealth funds and what have you not. The utilizers, the individuals, you sell your shares on the stock exchange, you're raising funds, right? You're a company trying to sell debt securities or equities, you're raising funds, you're utilizing funds. The government sell bonds, they issue sovereign bonds, right? Corporates share commercial papers just to raise funds. Now, intermediaries are anybody from your stockbroker to your trustees, to your underwriters, people that facilitate the deals. Even the legal experts like the lawyers, the capital market specialists that pretty much serve as transactional solicitors are all facilitators. They're importantly, the central securities and clearing system is a depository system of every transaction that happens in the secondary market, which is on the exchange. From share details to who is buying, who is selling, how it was bought, how it was sold. You look at what the central securities depository system is doing. It's very important. So to that extent, we want to talk about what we do, how it impacts on that activity. And I'll quickly say this before I run this presentation up. I want us to take his attention to Article 2.4 of the Ndpr. It's very important. It's not in my slide, but let me talk about it. The reason why I want to talk about it is that it says that consent and due diligence is important. For every transaction you're doing, every activity you're doing, you need due diligence, right? And you need consent. However, you do not need consent when it involves a mandatory requirement of the law to disclose. You do not need consent when it involves a contractual activity, a legal obligation, right? So for instance, what do I mean by this? If you want to transact with me, you do not need my consent to do a due diligence on me because you want to know, it's like KYC, know your customer, know your clients, know your business partner. So you can go to any public record. For example, if I'm a legal practitioner, you can go to the Supreme Court, you can go to the NBA and verify every detail about that information. If I say I'm company A You can go to the CAC without even talking to me. Run a corporate search on that company, let's say ABC Limited. Know who the company is, its registration number, its details in terms of its particulars. Now, the reason for that law is that you want to protect people. You want to ensure that they know who they are dealing with. People use aliases, people use pseudonyms, people use different sort of things, just to pass off and to evade detection. So when a man tells you that he is this, you want to be sure that he is who he is. So the law allows you to do that. But then, if you do that, you're doing that strictly for the purpose of which you are interacting with him. So if it's for the purpose of negotiating a contract or signing a contract, you can only use that information for that purpose, so long as you can attest to the fact that it's publicly verifiable. So when we think of this information, it will definitely help us understand the role which the NDPR plays in capital markets as a whole. Is it relevant? It is at the very foundation. So from talking to your stockbroker to the point you do a transaction on the secondary market is important. From the point you say you want to subscribe to a public, so MTN did a public offer recently, and they had this digital platform, this app where you go on. That is subject to the NDPR, that particular app. So the fact you're going to open an app and say I want to subscribe for 10,000 of MTN shares, the NDPR applies to that particular transaction. So the owner of that app cannot use your information anyhow other than for the purpose for which you have given that information, which is subscribing for some units of MTN shares, right? So this pretty much gives us a clear understanding of what we're talking about. I will wrap up things now to allow that people make their intervention. So please just walk me through the slides, the last slides, and let me complete my presentation. Yeah, so this is pretty much the These are the exchanges, the Nigerian Exchange Group, FFDQ. These are like self-regulatory organizations that offer secondary market activities from securities to debt equities and what have you. So from equity to debt securities. The next one, please. Yeah, and at this point, I would wrap up with this. Data protection implication for the capital market. I believe from what we've heard so far, from what I've said so far, the overwhelming answer would be yes. Now, if you have a yes for an answer, who is affected? Market regulators only, definitely they are affected. Market participants like you and me, the individuals that invest our money, that take out money from the market, yes, we are affected. The exchange itself, of course, because the exchange pretty much stores our information. So if you want to know how many stocks are purchased as the Turkey and Stephen Woyu on that exchange, they have information. If you want to know every transaction I've done, they have that information. If I've used a different name to purchase that particular stock, they pretty much know. And these days, let me say this, these days it's become pretty much impossible to do that because recently the CSCS sent an information to say, for you to buy stock, you must provide your national identity card. You must provide your name number. And you could see the underlying philosophy. They want to know who is transacting. They want to know who is in the exchange. They want to know who is buying what and who is owning what. And the same applies for corporate entities. So at this point, I believe we've pretty much covered the field from what is data protection to the Nigerian data protection regulation, as well as how it applies to the capital markets. We all have a fair sense of what the capital market is all about. And I would like to end my session at this point. Thank you very much.
Thank you very much, Mr. Stephen, for that insightful presentation. I'm really grateful for the perspectives you've taken us through. Now I'll call on Ms. Bukola Ogoshakin to take us through the next phase of the conversation. You have the floor, ma'am.
Thank you so much. Please confirm if you can hear me.
Yes, we can, clearly.
Okay. I'm using my device, so I sent in my presentation.
Yes.
You can help me display. Thank you. So I'd like to say a very big thank you to the entire ESP team, Barrister Fashola and his team members for inviting me here today. I also want to say thank you to my fellow panelists. I think Mr. Wanye has done a very thorough job with the intro.
Thank you.
When they were saying 20 minutes to discuss data privacy, I was just smiling. But at least we'll try. Okay, so awesome. I don't have much time, so let me just go right to it. Thank you also to the attendees as well for logging on to this session. I trust that you will learn, a thing or two from this session. So my topic is the Ndpr, the implications for the Nigerian capital markets. And as I said earlier, Barrister Nwonye has done a very good job to outline what it is and the regulations surrounding it. So I'm just going to go directly to the objective. What are the objectives of the NDPR? Article 1.1 of the NDPR states that it is to safeguard the rights of natural persons to privacy, emphasis on natural persons. B is to foster safe conduct for transactions involving the exchange of personal data. And I'm sure we know that in the past, in the capital markets, there is definitely a lot of transactions that take place on a daily basis. C is to prevent the manipulation of personal data. We know of the very popular Cambridge Analytica issue of accusations of certain tech companies manipulating personal data in their possession, for gain or for profit. And so the NDPR is trying to prevent such. And then D is to ensure that the Nigerian businesses remain competitive. So we ensure that we have safeguards. So for instance, exporting, importing of data and all of that, we need to ensure that there are safeguards in place so that there is no data flight and all of this. And also to ensure that we are in line with best practices. Okay, next slide. So what is the scope of the NDPR? Article 1.2, it states it is to regulate manual and electronic processing of personal data. So if you have a company and you have a register downstairs where people come in, sign in, put in their personal information there, NDPR ought to regulate that information. So it's not just digital data that we're talking about manual data as well. B, it applies to natural persons. This would be residents, who live in Nigeria or outside Nigeria. So it has extra territorial scope. It also protects data privacy rights guaranteed by Nigerian and foreign laws. So what does this all mean? It means that all capital market players, operators, the banks, the issuers, everybody, even the lawyers, that play in this capital market space are within the scope of NDPR. It also means that all finance and fintech players also are affected because they're either, as we've heard explained, they're either data controllers or data administrators. A data controller will be a person who determines the means and purpose for which data is used, and a data processor or administrator will be the person processing data on behalf of the data controller. It also means that local and foreign, investors, residents in Nigeria are affected by the NDPR. It also means that when we are talking about traditional finance and decentralized finance, it also applies. Next slide, please. So how is the capital market affected or impacted? Well, the capital markets conduct several transactions for which we have registrations, applications, returns are filed, reports are filed, all of this including personal data. So they're definitely affected. There's a lot of customer due diligence that takes place within the space. There's a lot of data processing, and this is mandatory by regulation as stated in the Investment Securities Act. Then we also have the KYC, AML, and CFT policies, which the capital market players need to adhere to or at least have. So that would, mean they will have to retrieve personal data from several data subjects. There's also foreign participation and interest. So companies coming into the country, NIPC would have us registered several investors. So that also affects the capital markets regarding NDPR, then capital transfer processing as well. So we're generally saying there's a lot of transaction, a lot of processing, a lot of information gathering that is taking place. Outside of NDPR, we now even have like regular clients, relationship management, market data, all this risk assessment and management, pre and post, trade processing that takes place within the capital markets. So definitely the capital market is highly impacted. Next slide, please. So what I did was to put up form set 2 for us to take a look at. Now this form, as we're looking at it, definitely, collects a lot of data and personal data at that. You're asking for their name, their residence, their date of birth. You're asking for state of origin, father and mother's details, even the mother's maiden name. So we can see that there's a lot of information being collected just with this form set 2 that I'm displaying right now. And not only that, there are several other processes that will ask for NIN, TIN, photographs, and more. All of this data being collected is personal data. And so therefore, we need to, in the capital markets, adhere and comply to the Ndpr. Next slide. So we need to look at the principles of the Ndpr. What are the principles? As a capital market player, what are the principles you need to be looking at? First of all, for every information that you collect, for every personal data that you retrieve from the data subject, you are accountable. I've written the sections there, the articles for reference. There must also be a specific purpose for which you are collecting that data. So you can't just collect data for any reason whatsoever. No, it doesn't work like that anymore. There has to be a specific purpose, which we'll look at again later. We also have confidentiality, integrity, and availability, CIA, for which explains itself. The information you collect must be confidential, must remain in the state it was collected, no manipulation of the data. You must make it available as and when due to the data subject when they require so. Data minimization is also another principle. Like I showed form set 2, there's several information that we retrieve from data subjects on a daily basis. Is all the information actually necessary? Can we break this information down into only the necessary bits that are needed? This is what data minimization, talks about. You don't need to collect the whole details about the person just because the person is trying to register something. It must be just the essential information. There's also storage and security. You must store the data appropriately. You must make sure that the data that you retrieve from data subjects is kept secure. Then also it must be legitimate and it must be lawful. So these principles are very important for us in the capital markets, for us to consider when we are retrieving or collecting personal data from data subjects. Next slide, please. We're going to go next to the lawful basis for processing data. So what are the lawful basis for collecting data? We have contracts. So maybe the person has entered into a contract with you, then you can retrieve the information from the person. For instance, if I want to order something from Jumia, Jumia would need my name, my address, my phone number, but Jumia does not need to know how many children I have. Jumia does not need to know if I'm married to send me that item. So, but for the contract basis, the information of name, address, and phone number is under contract. They make that information. Consent is also necessary. It must be freely given, and not manipulated not retrieved in a way of manipulation. Okay, then legal obligation is, for instance, under the laws, e.g. KYC AML, under anti-money laundering laws, you are to retrieve certain information. So under that, you can quote, okay, by section 9 of the AML, I'm required to retrieve so and so information from you. So that's a legal obligation. Vital interest would be in case there is maybe like a life or death situation. You need to retrieve the information and there's nobody to give consent, there's no contract, and it will affect the person's life. Then you can go for vital interest. Public interest would be for the public safety, national security, and all of that. Legitimate interest is not necessarily quoted under Ndpr, but in the data protection implementation framework, it does mention legitimate interest. This would be if there is no other basis that is necessary, but you still need to collect the information based on, for instance, to prevent crime or to prevent fraud. For instance, CCTV cameras most likely fall under legitimate interest because you want to prevent crime in your maybe supermarkets, for instance. So that's the legitimate interest. Next slide, please. So the data subject rights is what we're going to next. What are the data subject rights? The data subjects, my fellow colleague has explained to us earlier, but I'll just go through the rights really quickly. Right to information. I have right to information, my information. I have a right to access my information that is with, a data controller or processor. I have a right to deletion or erasure. I have a right to rectify my information. I have a right to port my information where applicable. I have a right to object to processing of my information, and I also have a right to restrict the data controller from, processing my information. So these are the rights of the data subjects. Next slide, please. So when we're talking about non-compliance and penalties, we've also gone through this. Article 210 of the Ndpr states that if you're in breach of the data privacy rights, you would be liable to the penalties mentioned. It also says, in addition to this, there could be any other criminal liability. So we have to keep that in mind. So the 2% of annual gross revenue, if the data controller controls information of 10,000 data subjects and above, or 10 million naira, whichever is greater. And for a data controller that controls the data of 10,000 and less, it will be 1% of annual gross revenue or 2 million naira, whichever one is greater. Next slide. So what's the business implication of non-compliance? In the capital markets, what are we looking at? We're looking at reputational damage. We're looking at impacted bottom line, porous security. People might not want to invest. Investors may be scared of investing in the capital markets when they know that we're not complying, to data privacy laws. There could be data breach if you do not comply with the Ndpr. There could be customer loss of flight because, I would rather go to a company that, respects my data and complies with the law regarding my data than an organization that does not. So there could be capital loss in that. You could face litigation, prosecution. There could be also costs involved. So there are PR costs, legal costs, remediation costs. There's so many costs that could go along with not complying with the Ndpr. So it's safe to say it's safer to comply to the Ndpr. So what are the implications on the capital markets? Next slide, please. Implications on the capital markets. So there are 4 stages that I would like us to look at when we're talking about the implications on the capital market. The first is the capital markets need to pay attention to cybersecurity and data protection too. Very, very important. The next will be GRC. Governance, risk, and compliance need to be our watchwords when we're designing our systems. The regulations regarding capital markets as well need to be updated. And then there needs to be training and awareness, which, like today is part of that. So the first one, which we're going to talk about, next slide, is cybersecurity and data protection tools. Each capital market operator needs to have a cybersecurity framework. Now, for you to have a cybersecurity framework, you need to either hire a skilled professional to do this for you, or you outsource to an organization that could, design or create a cybersecurity framework for you, because of the sheer volume of data that is being processed on a daily basis in the capital markets. Secondly, there needs to be physical and digital access and security and control. You need to control who has access to what and when and why, in fact. So what this would entail would be to have security levels in the organization. From small organization to the largest organization. The smaller ones might not really need high security for information, but the higher you go with the amount of data that you're handling, you need to have access control, security controls for your information. Thirdly, you need to put in place network security monitoring tools. Again, you need to get a skilled professional to do this or outsource this to a cybersecurity firm. Then you need to employ pseudonymization, redaction, and encryption techniques when storing information. So pseudonymization would be to replace the user's information with generic names or generic information. So instead of calling the person Mrs. Bukola Ogushaki, you could say user A or user 1161. Nobody knows what user 1161 is unless you can, marry the information together later or put the information together. A redaction will be a person can see a document, but parts of the document have been redacted and removed, especially the sensitive areas of the document, so the person doesn't get the whole picture. And encryption will be the use of public and private keys to secure communication generally. There's also penetration testing. Again, get a professional or hire somebody who can do that. Antivirus software, firewall tools. I mean, the list goes on, but at least these would be a basic consideration, for if you're looking at cybersecurity framework within the organization. Next slide, please. So the second one we're going to be looking at is GRC. This is a direct implication on capital markets for data privacy as well. The first thing is privacy by design. There needs to be proper analysis of clients, project scope, what are we doing, what do we need, what kind of personal information is going to be gotten. And in that process, whatever system you are designing, privacy is already part of it from the get-go. You're already designing your privacy notice, your privacy policy, your cookie policies. All of this is already in place from as you're building the system. So it's not like you've already finished building the system and then you remember that privacy is somewhere. No, privacy design will be from the beginning and working your way up to it. So adopt a GRC system that works for your organization. The second thing would be that legal teams and the general teams must analyze and understand the nature of the business. So the first thing you need to ask, the type of personal data being controlled or processed, that needs to be considered. You need to determine the legal basis for processing such data. So what you're doing is identifying. And then after identifying, you must notify the data subject. And you can notify the data subjects via the privacy notice, for instance, that you put on your website, or either if it's manual, it will be in printed form. If it's digital, it will be somewhere that the data subject have access to. But you're generally notifying them of what you are using their data for, so they have knowledge of it. And then number three will be the usage of the data and storage of the data. So you need to document as well. So ideally, what we normally say is you identify, you notify, you document, and then you do this process again and again. It's a circular, movement. Also, data protection impact assessment is very necessary. You need to conduct that based on the regulation of Ndpr. If you check the data protection implementation framework, you will find guidelines on how to go about this. But generally, you will need to get a DPCO to do this for you, because there's a verification aspect that the DPCO will need to sign. And unfortunately, this cannot be done by a data protection officer within the organization. It must be done by a DPCO. And if you need a DPCO, you can go to NICDA's website. On the website, all the DPCOs are listed there. You will need to work with one of them to get your DPIA done. Now, for those who are exporting data or transferring data from one country to another or cross-border, you will need to consider getting a transfer impact assessment done, because you need to look at the data privacy of the country that the information is being exported to, and then to make sure that they're in line, with our own data privacy laws, or if theirs is higher, like the EU GDPR, then you need to conform to them. So this, you could check the whitelist as well. I believe that is also on NICDA's website. Fourthly, you need to consider several steps before conducting customer due diligence, which a lot of capital market players usually conduct. What do you need to do before that? You need to have standard non-disclosure agreements, because information cannot be, just flying everywhere. People who have access to certain personal and sensitive information. So you need to have them sign non-disclosure agreements. There need to be data protection agreements. And usually the data protection agreement will be between the data controller and the data administrator or data processor, or between two data controllers, or between two data processors or administrators, whichever way. Once you're conducting any form of exchange of information with an administrator or controller, there will need to be a data protection agreement in place. So you need to conduct all of this. Also, you need to update warranty and indemnity. So there's additional warranty cover when it comes to data privacy. So you need to be indemnified for the personal data that you are exchanging, basically. And this is very, very relevant for the capital markets. Next slide, please. So for updated regulations, what are considerations? The value of data has definitely increased. We've been hearing data, everywhere is data, so the value has increased. Try to subscribe to a regular data research site now. There was one I tried to subscribe to. I think they were charging $10,000 or something like that along those lines. So the value of data has increased. Data can no longer be misused, unfortunately. The principles of data protection must be followed. Must is a must. So we need to consider that. The trust system has also changed. We know that now they're decentralized systems because people do not trust organizations with their personal data. So now it has created this decentralized movement that is going around. So trust has changed. People are right now on zero trust levels. So it's very important that once you're processing people's personal information, you need to let them know what the data is being used for. You need to be transparent with them, which is even part of the principles of data privacy as well. Also, we need to revise the data collection methods. Like I gave the example of Form Set 2, there's certain information that may not be necessary for some forms. We can remove such information and only collect the vital necessary information. And so that's very important for regulation. There are now more communication options. These need to be considered. Also, new tech is more invasive. We have more cameras, microphones, a CCTV camera everywhere, internet, phones, anything that happens, people are already bringing their phones out to record what is going on. So there's generally more surveillance and intellectual freedom, and this needs to be reflected in our regulations to update them. Okay, so finally, training and awareness, very important. Within any organization, you need to train every single member. Gone are the days where security and data was just for the geeks that were in the computer IT room. It doesn't work like that anymore. Everybody needs to understand what data privacy is about within the organization, especially when you're dealing with personal data. They need to know what it is. So we're all, each team member plays a key role in ensuring there are no loopholes, especially with regarding capital market projects. So they all need to know what it is. They all need to know what the process is. When you are designing a cybersecurity framework or GRC method or model, everyone within the organization needs to understand, at least for their own security level, they need to understand what it is. And then as the security level gets higher, you educate the higher security personnel again on what is expected of them. Okay, also it says here you are only as strong as your weakest link. So don't mind that you can't say within a capital project team that these people don't really need that information. No, as far as they're part of the capital market project or organization, they need to know about data privacy and their key role in ensuring that the organization is compliant. The consequences of a breach or non-compliance will affect the entire organization. So if there's reduction in investment, it will affect every single person on the team. So the consequences will be borne by all. So everybody as a team member needs to be trained and they need to be aware. And then teams and projects must proactively protect data and be trained accordingly. So very important again, we can't reiterate this enough, that everyone needs to understand what it is. I mean, they don't need to understand the whole Ndpr, but what we're saying is the systems that you have put in place within your organization, especially in the capital markets, every key player must know their role and be able to run with it. Where there is a data breach, it won't be good for the entire organization, and so you must carry everyone along. So with this, I think I've come to the end of my presentation. We can take questions later on. Thank you so much again for having me.
Thank you very much, Ms. Ogunshakin, for that presentation. Very detailed as well and useful. We would move on to our last speaker. I must say to each of our attendees that if you have any questions, please use the Q&A button in the Zoom app there to type your questions, and they will be attended to immediately after the third speaker's presentation. Mr. Samuel, you can make your presentation now. Thank you very much.
Okay, good afternoon, everyone. It's a pleasure to be here. Please, can you share the slide? I sent the slide before now to you. Can you hear me?
Yes, I can hear you. I'm working on that.
Okay. So while he's doing that, I want to seize this opportunity to appreciate my two senior colleagues that have spoken on this subject matter. As a matter of fact, they have greatly covered the field. So I'm very certain that no one is in doubt what personal data is, how it affects capital markets, and the benefits that also comes to capital markets operators by complying with Nigerian data protection regulation. So my topic will just be on the challenges and opportunities presented by Ndpr for the Nigerian capital market operators. And that is the reason why I've said that they have greatly covered the field. So I will just read my slide and we end the day. So that is it. Please turn to page 1. Now go on to the slide. So to start with, for anyone that wasn't late and come and work, carry out business. When first arrive, always change, either like awareness, culture, or the wearing. One thing the change. There's always a consequence that comes with it. So you coming to us maybe while you were on stage at school, you used to wake up at 7, 8.
I think Mr. Samuel is having some challenges with his network. He's already back on again. So
I'm so sorry. Please, where did I stop? So I was saying
we
that
could barely Okay, we could barely hear you at the initial stages of your presentation. Your network was a bit itchy. So maybe you could just,
but I
yeah.
can hear you well now.
Yeah, it's
I
a
said,
bit better.
yeah, for any person that is in Lagos and who wasn't born in Lagos, maybe you moved all the way from, let's say, from Oyo State or Ogun to Lagos to either do work or trading or carry out any sort of business, you realize that there is always a change. You have to adapt to the condition in Lagos. Maybe while you were in your state, you used to wake up by 7 a.m. And coming to Lagos, you notice that you have to wake up by 5 a.m., especially if you are staying in mainland or far place, let's say Shangote Aja, for you to beat Lagos and get to your place of work on time. Now, one thing is certain with change, it has a consequence. The consequence might be positive, it might be negative, or even both. That is the case with Ndpr. So the enactment of Ndpr comes with its negative impact and also its positive impact. So it's left for the person doing it to look at the negative impact and the positive impact and be able to decide which one will pay him or her better or best. Please, can I see there is no need going to talk about what personal data is. It has already been spoken by my senior colleagues. Please, can you show the next slide? So we'll be looking at the challenges that Ndpr has on capital markets and on capital market operators. And the first thing we'll be looking at is the growing complexity of compliance. When you look at Ndpr, Nigerian Data Protection Regulation, you see there are a lot of things you need to comply with. You need to comply with the legal basis. My senior colleague spoke about it, whether you are relying on consent or contract, whether you are relying on legal basis, whether you are relying on public interest or authority or vital interest. So you need to assess this and know the best or the one that is best suited for the processing activities you want to carry out. So, and when you do this, you have to document it as a matter of fact. That is a compliance. And mind you, you have to, you have to spend for you to do this, because if you don't have the knowledge, you need to secure the service of an expert to advise you on this. So we have data protection audits. This is a compulsory thing that you have to do once every year, once you come within the regulatory ambit. We have a privacy notice, data protection impact assessments, data subject access request. These are the things you comply with in Ndpr, and they are not cheap, as a matter of fact. So that is one. So when you look at this, you see that there are a lot of things you have to comply on Ndpr, which are very much expensive to do. Now, another thing you have to look at under this growing complexity of compliance is that when you look at other jurisdiction, okay, let me just say that for someone that has opportunity to look at GDPR, we know that GDPR applies extraterritorial when you look at Article 3. So if you are offering goods and services to any state in I'm aware that some market operators also target Indians that are not residing in Nigeria and even foreigners. That's section 21 of Nigerian Investor Promotion Commission. Has given foreigners the right to Nigeria 100%. So it's aware of, when you look at that regulation, you see that it's foreigners. So you are complying with GDPR. GDPR has some relation with Hello?
Hi,
Hello?
Mr. Sama.
Yes, can someone hear me?
Yes, we can.
Okay, I'm so sorry about what is happening. I think it's a network problem. There's little or nothing I can do about it. So, when you look at the provision of GDPR, you see it applies to people who are in, let's say, a controller in Nigeria offering goods and services to a person. California has its protection laws, has its protection law. So if you are offering goods and services to people in these places, you need to substantially comply with the data protection law. So there is complexity coming from data protection compliance that capital markets and capital market operators have to, do them to get good in their business. Let's go to next slide. Next slide, please. Next slide. Next. Hello. Hello.
Hi, Mr. Samuel. That's the next slide. This is the next two slides already on the screen.
Okay. So financial implications. That's the second challenge Ndpr has on capital markets and capital market operators. So when Ms. Buki was talking, she spoke about the data breach cost, the penalty costs, the implementation cost, and the remediation cost. So when you look at the implementation cost, just as I spoke in the first slide, for you to implement data subject access requests, data protection impact assessments, and all other compliance, legal basis, and etc. You really need to budget certain amount of money because you need the service of a legal practitioner in data protection or a cybersecurity practitioner who will help you to do this. So that will attract costs to a capital market operator. You also, there is the issue of data breach cost. Now, where maybe as a result of not complying with the provision of Ndpr, or you have even complied, but there are still one or two gaps that you were unable to discover, a breach occurs, or maybe the breach occurred as a result of insider threats. Maybe an employee going to access personal information of a client or an investor that is not supposed to, or decides to take a laptop that contains the personal information of an investor home, and another person decides to see it, and or that these are data breach. Now, for you to, let's say someone there is an issue of ransomware, or someone phished the device you are using to do it. You need money to recover that from the person. Sometimes they will bill you, millions of naira for them to grant you access to the database again. So all these things are costs that comes with data protection. So we have the penalty cost. They have spoken that if you do not comply with Ndpr, you will be fined up to 10 million. So, Sokolon was fined 10 million, and one other fintech company was also fined 5 million. So it's mitigation cost is data information, and the person decides to write it that and decides to exercise his or her rights before the court. So if NIDA finds you guilty, NIDA will still fine you with 10 million, and the person can still go to court and claim damages. The damage can, can be up to 50 million, 100 million, 20 million or less, depends. So we have the remediation cost, where let's say you are a capital market operator and you want to start complying with the Ndpr. You will invite a data protection practitioner who will come and look at your activities and try to see where you are not complying. Now, once the person identifies those areas you are not complying, the next thing is to remediate it. It's a way of trying to, close up the gap. So all those things definitely cost some money. So we call it remediation cost. Please, can you go to next slide? So what organizations do, and that is also what I'm advising capital market operators, is at the beginning of the year, just as you make budgets for every other thing, salaries of your employees and some other incidents that may happen in the company, you should also make a separate budget for data protection compliance and some expected fines or costs that will come from it. So we have another challenge. We have poorly trained staff and management. A colleague, a senior colleague has spoken on this issue. So where your employee, in fact, is not where, I'm very much aware that most capital market operators, both their management and the employees, are not trained in data protection compliance. So for you to do that, it's going to cost you money. If you don't do it, it will still cost you money, because there will definitely be data breach coming from your employees and also from you. So whichever way. So having poorly trained staff and management is a challenge. And just as you all know, it is not always easy to adapt to anything. And data protection law is very new in Africa and to Nigerians. So adapting with the technological difficulties associated with it is becoming a very big challenge to capital markets operators and even other organizations. So all these things are challenges that are facing any organization that would like to comply with Ndpr. Please, next slide. Lack of qualified privacy practitioners in Nigeria to help you achieve your compliance. It is one thing to have the money, to have the will to comply with Ndpr. It's also another thing to have people that know how to help you comply with Ndpr. So in Nigeria, from the lawyer's perspective, we have just very few lawyers in this space. Now, from cybersecurity perspective, we also have very few people practicing data protection in Nigeria. So this presents a big issue. How do you now comply with Ndpr? So if you don't comply, you are not going to give the regulator an excuse that you don't have a practitioner that will help you to comply. So all these things help to present issues. So the very few people that are practicing it will definitely be very expensive. Their charge or remuneration might be higher than the budget you have. So all these things joined together are challenges facing capital market operators and capital market in complying with Nigerian data protection regulation. So we are looking at, just as I said, whatever thing that has advantage will definitely have a benefit. So we are going to look at the benefits that Ndpr presents, and one of it is it makes Nigerian capital markets and capital market operators to remain competitive in the global space. Because of how the regulators in EU are clamping down on companies that are not complying with data protection regulation, that's the GDPR, it will be very difficult for any person in EU to transact with any capital market operator in Nigeria who does not have a robust data protection compliance background. So for you, it has become an issue now. For you to remain competitive in the global space, you have to comply with the Nigerian Data Protection Regulation, which substantially complies with the GDPR. So that is it. For any capital market operator to remain competitive in the global space, you have to comply with the GDPR. And when you do that, it gives you a marketing edge over those who have not complied, because investors will be more inclined to trade with you or to invest with you than other persons. I mean, other operators or players in this space. So we also have breach mitigation. So when you look at the way Ndpr is drafted and its compliance, when you look at some of the things he said that any person transacting in the business of personal data processing has to do, you see that it has a way of keeping organization in their toes, and this will help to, kind of solidify their security measures, so there won't be issue of ransomware attack or phishing. Because when you have a solid privacy policy that will direct an employee what to do or not to do with personal data, where to go to and where not to go to, the system to use and the system not to use. And maybe in the privacy policy said, don't bring your personal system to office, don't work with personal system, don't take firm's personal laptop home. Then it has a way of minimizing the risk that could come from data breach from that angle. When you take your personal data home, there is possibility for your friend to come around and access an investor's personal information. So it has a way of preventing this risk. Now, if you have, Ndpr said you must install adequate security, you must make use of encryption, use strong antivirus and all that. So if you have all these things in your system, your digital app, then you see that it will be very difficult for you to be caught by all this ransomware and phishing activities. So that will help to minimize the breach, data protection breach, and the cost that will come from data breach. Next slide. So another thing is competitive advantage. Just as I stated before, that complying with Ndpr will make an operator, capital market operator, to remain competitive in the global stage. Now, what organizations do right now is, once they achieve solid compliance with personal data, with Ndpr or GDPR, they use it in their marketing strategy. They have a way of telling people, see, we have solid privacy policy. We can assure you that when you transact with us, your personal information will be protected. And when you look at business, people transact with organization or with any person based on trust. So when you show people that when they keep their personal information with you, when an investor learns that if he keeps his personal information with you, that the information will be protected, then that investor will be more inclined to transact with you than someone that he doesn't trust. Someone that is sure that, okay, there is possibility that this information can be hacked, the database can be hacked, and a third party can see my personal information or even my investment with the operator. So that's it. So companies that have solid data protection compliance now use it as a competitive marketing strategy over those who do not have. I've talked about trust. So capital markets is a data-driven sector, ranging, you get someone's NIM, and NIM itself is a database, because once you have someone's NIM, you can access the person's information, anything you want about the person. They collect someone's BVN, your marital status, gender, all these things, where you are from, and other. So an investor will not be willing to entrust those information to an operator who is not complying with Ndpr or who doesn't have a robust data protection compliance policy or privacy policy, as the case may be. So for you to engender this trust before your investors, then capital market operators, including the SEC, they must have a robust data privacy policy that will tell any person, employees, or any person dealing with personal information what to do and what not to do with the personal information. Next slide. So, increase in share value. Where an operator in capital markets, let's say an investment bank or even bank, these are operators in capital, stakeholders in capital market. Their shares listed, they see that they have data protection compliance. There is less likelihood that they will be fined by the regulator. So because they have taken steps to secure their database, they have taken steps to comply with all the necessary things that the regulator have said they should comply. They don't have fear. They can, increase their share value. Tell an investor that, see, when you purchase this share, you are not going to be fined by the regulator because we have taken care of all these things. It's just like people, when a company wants to acquire another company, all these things. So these are some of the things they look at in due diligence to know, okay, is this company, does it have any litigation? Has it complied with CBN or CAC or even SEC, all these things? A company that hasn't taken steps to comply with all these people, it will definitely bring down the value of the value before the people acquiring it. So that is the way it applies in capital markets. When you have substantially complied with Ndpr, it has a way of increasing your share. But if you have not complied, the acquirer may tend to price it down because he knows that if he succeeds in acquiring it, you will go all over again to start complying. And these things involve money, just as I said. For people that are, if you have read the case of Marriott acquired one hotel in UK. That hotel, because they didn't take steps to comply with the data protection law then in UK, that's the directive. They had some gaps and they were under investigation. Marriott didn't get to know this. When they were carrying out due diligence, they didn't request for some compliance, record of processing activities. So Marriott acquired this company, and around 2019 or thereabouts, the ICO, the UK regulator, had to fine Marriott $18.4 million US. And because of that, Marriott had to, they had to wind down because they couldn't continue with the business again. The same thing happened with British Airlines. When it was fined by the regulator, it brought down their share value. They were literally, begging that the regulator should cut down the money so that they will be able to even trade again or continue with their business. So these are the implications it can have on capital market operators. It can affect a company's share, it can affect an investor's share, and it can make an investor price down the share of the company. Next slide. Okay, so with this, I said thank you. And I wish that all capital market operators here today, after this webinar, you have every cause to start complying with the Nigerian data protection regulation. So thank you. I'm available for questions.
All right. Thank you very much, Mr. Samuel, for that presentation. Thank you so much. We'll move to Q&A right away. And we'll just take a few questions because our time is very fast spent. We have two questions in the Q&A tab right there. The first question says, is it necessary for SMEs, for example, like a cake baking shop that collects some form of personal data, to have a data protection officer? Would any of you want to answer that?
Well, okay, moderator, should I answer?
Yeah, please, you can go ahead.
Okay, okay, thank you. So I think we need to be very realistic here, right? So for a one-man business, you are pretty much the data protection officer, right, or data compliance protection officer. The idea is that the law applies to you, so long as you are involved in collecting information of a data subject, either by name, by payment details, or whatsoever, you are required to comply with the law. But nobody expects you to employ a data protection officer and pay the person for that purpose. But the idea is that you should keep adequate measures to protect the identity, the information made available to you for purpose of that transaction. So take for instance, even for us law firms, here we send out emails, we have confidentiality notice. We have policies on sending out emails to clients. We have policies on handling digital files or digital agreements of court processes. It's pretty much compliance with the law, right? So I think even for the informal sector, there's a measure of compliance, so long as it involves payment to some digital platform. But if you walk into a shop and just pay with card, and you pick up an item and leave, I don't think anybody would keep a detail of who you are or what you purchased per se. Maybe they'll say, okay, a bottle of this was sold for this amount, and that's just it.
Thank you very much. Thank you for the answer. Does any other person want to weigh in before we go to the next question?
I'm not to disagree with my colleague, and just to kind of look at the position of that should be one. Yes, every controller must designate a data protection officer. Now, when you look at the implementation framework, it's where I call it an afterthought, decided to introduce a limitation to say, okay, companies, let's call it public institutions, that's for people the DPO or that can appoint DPO, the same public institution or any person possessing sensitive, large amount of sensitive personal data, or any person monitoring or profiling an individual or data, any person profiling or monitoring aspect in a large. But I wrote another one to that since it's acknowledged in the implementation framework, that the implementation framework does not override the Ndpr, or better, that Ndpr overrides the implementation framework. Then Ndpr specifies that every controller has to appoint a DPO. Then it means that every organization has to do that. Even though I know that it will be very difficult, just as I said, for a one business to appoint a DPO, because you can't pay the person, honestly speaking. Like if you have up to 200, but then here in Nigeria, our law has said you have to. And in all sincerity, we'll go with the opinion that an SME has to appoint a DPO. We'll go with that because that's what the Ndpr says. So, but the implementation framework gave a limitation to say public institution, people processing sensitive personal data in a large quantity, and also people monitoring or profiling data subjects in a large quantity. So that's that.
Thank you very much, Mr. Samuel. Okay, so we'll just dive right into the second question, which says, by virtue of the Ndpr, are small companies as defined under CAMA mandated to have privacy notices as well on either their websites or anywhere else?
I think I'll take this one.
Awesome.
As far as you are an organization and you are collecting personal data of data subjects, you will be required to have a privacy notice because, like we said, once you are collecting any kind of data, either manually or digitally, you will be required to have a privacy notice. Now, the reason for the privacy notice, like we have said, is to notify the data subjects what you are using their data for. So as far as you are collecting that data, you need to notify them of the legal basis, the means you are collecting the data, what you are collecting the data for, what you are using the data, and where their data will eventually end up. For those that have third-party sharing of information, they need to state that. That needs to be stated in your privacy notice. So a privacy notice is not really about the size of the organization. It's more about the data that is being collected. So that size doesn't matter for that at all. It's just the use of the information. So it will be mandatory. Thank you.
Thank you very much, Ma. And we have come to the end of today's webinar. If you have other questions, you can reach out to us. I'll drop our email in the chat today. So, if you have questions, we can send them to each of our panelists and they'll send their contributions and we'll mail them back to you. We want to really say a big thank you, to every attendee here. A big thank you as well to the panelists. Thank you for sharing such tremendous insights on, the implication of Nigerian data protection regulation on the capital markets. And I personally have learned, a lot in terms of the depth of how, number one, in terms of, knowing your customer, the impact of all these conversations. And yes, maybe not so much as has been said about the capital market, but today now we have, some conversations going on, with regards to how data can be, managed and how the Ndpr can be complied with. We want to also say a very big thank you to our sponsors. And, we thank the African Law Practice. Thank you, Farmsville Solicitors. Thank you, GLIS and Co. Thank you, Duale Ovia and Alex Adedikpe. Thank you, Advocate Law Practice, Ever Law Associates, and Bloomfield Law Practice for making today's webinar possible. We also want to inform you that our next webinar will be on Tuesday. Do well to tune in by 1 p.m. and you can watch past webinars on our YouTube channel with the username MyESQLegal. Right, today's webinar as well will be available there. So if you are unable to attend or you were unable to participate throughout the whole session, you can always go back there, to listen again, watch and learn again. Thank you everyone for joining today. The webinar has come to an end.
Thank you so much.
Thank you very much.
Samuel, thank you so much.
Thank you, Bukola. Thank you, Samuel. It's been a wonderful session. Have a wonderful day.
Same here. You too. Bye-bye.
Bye-bye, everyone.